First to you, Aditya Pratap. You, of course, would have heard right now Prashant Patil speak exclusively to Mirror Now. My first question to you, what would you say to... I mean, how should one really look at this? With what the accused lawyer has spoken to Mirror Now, he seems to be saying that it was argued before the court very strongly with the sections that were put in. The bail was imminent, it was to be given, and it has been given. There's nothing wrong that has been done in this particular case within 15 hours. So if that's really the point, then is it about a wrong section being put in?
You know, give me some time. First and foremost, there's a saying, law is an ass. The sequence of events which have unfolded today once again prove the notion that the law is an ass. We are living in the 21st century where law is not supposed to be an ass. Law is supposed to be a vigilant eagle, because the scourge of crime is growing exponentially. Look at the sequence of facts here. We have a child, the son of a very affluent family, who takes out a Porsche worth crores, goes to a bar, drinks like a fish, and then goes and kills two hard-working people who have come to make a living in Pune. Now, given this factual scenario, let us look at the Juvenile Justice Act. Section 12 of the Juvenile Justice Act says, yes, bail should be given to a juvenile, but bail should not be given where it would defeat the ends of justice. Today, within a span of 17 hours, he has got bail. I'll ask one question. Was the public prosecutor given an adequate time to give a rebuttal? Whenever we move off bail, always the reply of the public prosecutor is called for. The public prosecutor and the investigating officer are to apply their minds. In fact, the court calls for the say of the PP. So it automatically spins over by a day or two. And here, same day, I mean, within hours, he's getting bail. I would like to say that this is a case where grant of bail has defeated the ends of justice, because drunken driving by teenagers, the alcohol culture
that's
is growing.
That's a point that you're making, and that also would require to be seen into. But Aditya, let me just get in at this point and allow me to just make a sentence here, because we are dealing with a sensitive case. You have made a statement that he drank like a fish. Well, to be factually correct on this case, let me just put across that part as well. We do not know whether that was the case indeed. That is for the police to make out yet, and that is to for the police to make a case out before the court. But that apart, I get the sense of what you are saying. Of course, you are upset also. But Aditya Pratap, help me to also understand at this point. When you talk about the order that has come out from the court today, about the essay that needs to be written, about the project that needs to be done with the traffic police, is this usually the norm with the cases that would be tried under the juvenile justice? Is this how it is, or is this a big deviation? And that's something that I'm trying to understand legally as well.
Yes. Well, let me share with you my personal experience. 4 to 5 years ago, I appeared before Juvenile Justice Board in Bombay, when a woman from Lucknow was thrown in front of the coming train by the juvenile. I appeared before the Juvenile Justice Boards. And I don't want to say anything of the proceedings, but right from day one, the disposition of the concerned presiding officer was, he is a child accused. He has to be treated with leniency. Now, whatever the law be, the law as it may be, but I strongly believe that in numerous instances, the presiding officers do not fail to acknowledge the fact that the Juvenile Justice Act was passed in the aftermath of Nirbhaya, wherein the crime by juveniles was rising and there was a need for stricter deterrents against crimes by juveniles. So,
the amendment to the juvenile justice was passed after. Just again, a factual thing for our viewers so they don't get confused. Aditya, just a minute. So basically, it was the amendment to the Juvenile Justice Act. That was the 2015 version that came up after Nirbhaya. Before that, you had the JJ Act 2000 that did not allow for a juvenile to be treated as an adult. Please go ahead, Aditya.
Yes, exactly. So the 2015 amendment made 3 categories: petty offences, serious offences and heinous offences. Now let me tell you from experience that the act has a major loophole which was flagged by the Supreme Court, but the government has done nothing to amend it. The definition of a heinous offence is any crime 10 years or more. So in short, the trouble is, like any crime, the minimum imprisonment, if you see the definition of culpable homicide under the IPC, punishment for culpable homicide under section 304, it is punishable up to 10 years. There is no minimum imprisonment prescribed for culpable homicide, because of which, in several cases, juveniles in conflict with the law have managed to get the benefit of this provision, because a culpable homicide does not have a minimum imprisonment. It does not fall in the category of heinous offences, and that is why they end up being unable to be tried as adults, when there is all the more need for delinquent juveniles to be tried as adults. And Supreme Court, I had appeared in a case wherein the Supreme Court ruling was applied. Supreme Court in its ruling said it is a serious loophole, but unfortunately we are not the parliament. We cannot legislate. And the tragedy is, 5 years have passed, many years have passed, government has done nothing to eliminate this flaw.
Okay. Aditya, if I can get you here, an important point being made by the doctor really. Intent, as it were, is a very important way of looking at cases legally as well. Courts really do look at intent as a very specific angle while dealing with juvenile cases. Is it the same while dealing with adult cases as well?
Well, we talk about intent. My learned friend, the expert here, said that there was no intent. Fact of the matter is, if there was intent, then the charge of murder 302 would have been added. Here, it may not be a case of intent, but here's a case of, at least a case of culpable homicide not amounting to murder. People say, look at a juvenile with compassion. I say, because of the current approach being adopted over the last several years of looking at a child in conflict of law with compassion and others, their delinquency is growing. Let's accept it. Alcoholism has spread in society. My learned friend
do we have any data, in fact, to say so?
Developmental phase is growing, etc.
Aditya, do we have any data to say so?
Well, I would look at specific. Well, I think one can of course look at the National Crimes Record Bureau. I can look that up and come back with the data for you. But today you have to look at the tendency among kids as a whole. There's a simple saying in English: spare the rod and spoil the child. And today, these children are running over people because their parents have failed to sensitize them. Now, one more thing. Today, we have a case where the child was let go in 17 hours. Let me tell you, in the case which had appeared, when the child was remanded to the juvenile home, the learned member had said that it is necessary for the child to be enrolled in the programs being conducted in the remand home so that he can come on the right path. Here, the order simply tells him to write an essay, work with the police for 15 days. In fact, such a child, it is all the more necessary because his parental care has failed him. When his parents have failed him, it is all the more necessary for such a child to be sent to the juvenile remand home where a proper program can be implemented for him. Sending him back home and asking him to work with the police for 15 days, write an essay, defeats the law.
All right. Aditya, how would you respond to the fact that even within courts, there seem to be so many twists and turns while defining a heinous crime? Like, there doesn't seem to be a consensus on a definition. There doesn't seem to be a consensus on what the benchmark would be legally between courts. You've had different verdicts from the lower court, from the high court, and then eventually Supreme Court. So this definitely is a big grey area legally, in the sense that there doesn't seem to be a clear answer. There are so many aspects. And is it particularly because it involves juveniles, in the heart of it?
Well, I would simply say that had the principles of statutory interpretation been applied, probably this issue would have been managed and sorted out. Now, I have the highest respect and regard for the Supreme Court, and the Supreme Court thought that just because there is no minimum punishment prescribed for culpable homicide, it cannot be classified as a heinous crime. I honestly feel that a grammatical and a logical interpretation of the statute should have been adopted, wherein any crime which is imprisoned, because see, like up to 3 years, 3 to 7 years is serious crime. By default, any offense which is punishable with 7 years or more should have been categorized as a heinous crime. The courts have to find a way through the statute, around the statute, and because how it is.
Look at what the Gujarat High Court has said in 2023. Let's just look at this. Aditya, let's just look at this. Spare a minute. Let me just read this out to our viewers as well. So juveniles to be treated as or tried as adults in cases of crime. One, depending upon the child's ability to commit the offence, the circumstances of the case, and the ability to understand the consequences of their action. It's quite varied and very subject to interpretation.
No, see, that is
Aditya?
the law drafted by Parliament. It is a duty of the courts to interpret and apply in a responsible manner. Likewise, today, when the child got behind the wheels of his Porsche, he was very well, he well knew, he got into his Porsche because he knew the car can do 200 kilometers an hour. And he, who studies in one of Pune's best schools, was well aware that गाड़ी किसी को कुचल सकती है. And he was well aware that alcohol is an intoxicant. So I strongly believe that he was well capable of understanding the consequences of his actions, and he took out that sports car in order to show what a spoiled brat he is. He wanted to show off, and he will reap the fruits of his show off.
I understand emotions are running high. Aditya Pratap, thank you for joining us.